On today's episode, we will be asking 4 questions. The first question is whether the purported removal of the Vice Chancellor of the University of Lagos, Professor Toyin Ogundipe, by the Governing Council headed by Dr Babalakin on the 12th of August 2020 was done in accordance with the law. The second question is whether the Senate meeting, which held on the 13th of August 2020, which had a vote in confidence in the Vice Chancellor, was also done in accordance with the law. The third question is if that Senate meeting was not done in accordance with the law, then what would have been the correct recourse of the Vice Chancellor instead of holding a Senate meeting? And then lastly, what exactly did the Vice Chancellor do wrong? And that is where we have the gist of the matter, which is going to be at the end of this video. So sit tight and let's enjoy the video together. Before we go into the gist of the matter, my name is Olayemi Dear Korola Daniels, popularly known as Dear Ko Spectre, and this is another episode of Dear Ko Talks Law. If this is your first time of coming to my channel, then I want to say a very big welcome. Make sure that you subscribe to my channel and also make sure that you click the notification bell so that anytime I release a video which could be of interest to you, you will be one of the first set of people to watch that video.
You know I'm making this statement because I'm a lawyer. I expect Ogundipe to sue me that I said that he has mismanaged the university recklessly, he has abused his office fundamentally, and he has behaved in a manner not consistent with his office. He can sue me.
Who sent you? Who sent you? Just wait, Jare, wait to the end of the video. Just wait. Now, moving into what we have today, let us go to the first question. Whether or not the purported removal of the Vice Chancellor was done in accordance with the law. Now, we have to ask the question, what does the law say about the removal of Vice Chancellors? And we are going to find that in section 3, subsection 9 of the Universities Miscellaneous Provisions Amendment Act of 2003. Do you understand? Another thing that you need to have in mind before we read these particular provisions is that there are 2 things in law. In case you are not a lawyer or you are not a law student, just follow me. There are 2 things in law. You have substantive ultra vires and procedural ultra vires. Ultra vires in itself means beyond power. So when you say something has been substantively ultra vires, it means that a person has acted beyond the power that has been given to the person. Now, to say something is procedurally ultra vires, it means that the person has acted beyond the procedure that, the power has been conferred upon that person. So, is it possible for the Governing Council to have the power to remove a VC but not follow the correct section, the correct method of removal, which is what the Senate is arguing in this circumstance? And the answer is yes, it is possible. So what we are going to be answering is, did they follow the process? According to the Act, it says that the Governing Council has the power to remove a Vice Chancellor. However, there are procedures laid down. So in order not to be procedurally ultra vires, let us take a look at what the provision says. But before we do that, let us hear Senate's opinion on this matter.
We're here because we want to make it known that the alleged or the purported removal of the Vice Chancellor of the University of Lagos has not followed due process, and therefore is illegal, cannot stand. We are not saying that the council has no right to remove the Vice Chancellor. No. We are saying due process has not been followed. There is a laid down procedure in the extant laws of the Federal Republic of Nigeria, namely the Universities Miscellaneous Provisions Act of 2003. It applies to all federal universities, and it provides for removal of a Vice Chancellor if there is a need to remove a Vice Chancellor on the basis of misconduct. The procedure is that there should be a joint committee of Council and Senate This has not been done in this case. And so we're saying it cannot stand.
Just so you know, the person that just spoke now is Professor C.K. Agomo, and she was the one who taught me contract law. I know, thank you very much. And also, the person standing beside her is Professor Senwa, just the immediate past dean of the Faculty of Law, University of Lagos. She also taught me criminal law. Yes, thank you very much. Now, according to the Senate, they are saying that this thing was not done in accordance with the law. That according to what the provisions of Section 3, subsection 9 of this Act says, it says that when the proposal of removal of the Vice Chancellor is made, the Council shall constitute a joint committee of Council and Senate consisting of 3 members of Council, one of whom shall be a chairman of the committee, and also 2 members of Senate, provided that the ground for removal is infirmity of the body or mind, blah blah blah. Now, you can see that according to this provision, it is saying that there must be a joint committee of Senate and the Council. Now, when Dr. Babalakin was interpreting this section, Dr. Babalakin said that you cannot interpret this section disjointedly. If you are going to interpret this section, you must read the whole of the Act in order to be able to deduce what the intention of the legislature was. And so, Dr. Babalakin referred us to Section 3, subsection 2. Note that Section 3, subsection 2 of this Act is talking about appointments of Vice Chancellors. Now, Dr. Babalakin is saying that according to Section 3, subsection 2 of this Act, it says that when you want to appoint a Vice Chancellor, you shall constitute a search team. Now, if you read 2b, it says that there shall be a search team which shall consist of a member of the Council who shall not be a member of Senate as chairman, and also 2 members of Senate who shall not be a member of Council, and one of which must be a professor. Now, let us read Section 3, subsection 9 again. If you read that provision, you would see that when the drafters drafted that provision, all they said is that they wanted 3 members of Council and also 2 members of the Senate. They didn't say that those 2 members of the Senate should not be members of Council, because if they wanted it that way, they would have said it expressly. According to Dr. Babalakin, you are not supposed to read the Act disjointedly. Read it in accordance with Section 3, sub 2b. You would see that the intention of the legislature is that there should be a joint committee, although when you are reading Section 3, sub 2b, that joint committee must comprise of members of Senate who are not members of Council, and also members of Council who are not members of Senate. And then when you read Section 3, sub 9, you would see that according to the provisions, it didn't say whether or not they should be members of Council or members of Senate. All that is said is that we want 3 members of Council and 2 members of Senate. So those people who are members of Senate can also be members of Council. Do you understand? So which do you agree with? Do you agree with the Senate, or do you agree with the governing council on their submission on this matter? Please write your comment down below. Now, on the second question on whether or not the Senate, that Senate meeting which held on the 13th of August, and also the vote of confidence in the Vice Chancellor was done in accordance with the law. Now, if you read the provisions of this same Act, it will tell you that it is only the Vice Chancellor that can, call a Senate meeting. Now, as at the time the Senate meeting was called, Professor Toyin Ogundipe, according to the decision of the governing council, already ceased to be the Vice Chancellor, and therefore it is submitted by the governing council that that particular meeting was void at law, which means that it was not in accordance with law. Do you understand that? But according to the Senate, they say that they do not recognize the purported removal by the governing council, and therefore, at the time the Senate sat, the Vice Chancellor was still the Vice Chancellor. So, do you agree with the Senate, or do you agree with the governing council? Put your opinion in the comment section below and let us know. On the third question of what would have been the correct recourse of the Vice Chancellor, it is submitted by the Governing Council that the Vice Chancellor only recourse was to appeal the decision to the visitor, and the visitor is the President. If the Vice Chancellor feels aggrieved as to a particular act done which he thinks was unfair or unjust to him, what he should have done was to appeal to the President on the matter. And then lastly, what exactly did Professor Toyin Ogundipe do wrong? This is the point where I will advise you to go and get suya, because popcorn cannot solve this matter. You need to get suya and get a bottle of Coke. So now, let us listen to what Dr. Babalakin has to say as the reason for the removal of the Vice Chancellor. I hope you are with your popcorn or suya or Coke. Me, I prefer Coke. Coke is my favorite drink. So let us listen to this together.
First, let me repeat that the council complied with due process in the removal of Professor Toyin Ogundipe. I've heard a lot of comments in all media, and these comments ignore a fundamental fact. Ogundipe has not denied any wrongdoing. He has not said that he did not spend 120 million renovating the residence of himself and two of his cronies without mentioning it to anybody. It was discovered. It was not mentioned. It was not presented, and there was no approval. That is patent illegality, and he has not denied it. Ogundipe has not denied that he created something very new in the university, the concept of security votes, or he continued it. I don't know when it started. But he pays security votes, which is money that requires no account in the university. He has not denied it. Ogundipe has not denied that he forged documents in trying to present a candidate for Director of Works. He was chairman of the committee, and he was told to collate results. When he collated results, second became first, first became second. He never denied it. He actually, on the floor of council, and it's in the minutes, did not have any comments about it. Ogundipe has not till today been able to present a proper account of the university. 3 sets of people have looked at the accounts. None have said that the accounts represent a fair representation of the university's financial position.
All right.
In fact, he concealed it until 2.5 years after council came in, when a Professor Omoleyinwa report found out that he had concealed information and he had presented what is not a budget as a budget. Ogundipe unilaterally sought to appoint a professor into the university. This is the worst scandal in the academia. He sent me a memo that I should approve that the librarian become a professor. I'm familiar with university system. You just don't become a professor. You must go through the process, and then it comes to council for confirmation.
Dr. Babalakin
did not go through any process.